The whole theme today is protecting your business, and it starts off, if you've got employees or you're thinking about employees, listen to what this guy has to say.
Thanks, Pat.
And you've got the clicker right here.
The clicker's ready to go.
Okay.
Okay. Well, good afternoon, everyone. It's great to be here. I represent a company that we started, 6 months to 9 months ago. It's slowly coming to bear fruit. We focus on outsourced human resource functions. It's a little bit different than the standard a la carte, any kind of HR consulting. We really focus in on some key issues, pretty much soup to nuts. We can handle a lot of various functions in the HR field. We really specialize in employee relations. What I'd like to do is kind of take you through a set of slides that I think you'll find interesting. We've got a couple of little scenarios and stories to kind of go over with you and some lessons learned. What we do is, and I'll let the slides talk a little bit, we talk about HR as a fact of what we call small business life. They really cause you to take your eye off the ball and focus on things that don't have anything to do directly with your bottom line, but can cause lots of trials, tribulations, and some expenses if they're not handled correctly. And a lot of companies just aren't prepared with the kinds of litigation type situations, discrimination charges that are present in the workplace. We've got a slide here that talks about some shortfalls. A lot of new businesses, and I always like to say, how about synergy as a business? Do we have these things? Do we have a handbook? Do we have HR policies? Do we have good, solid job descriptions that delineate what people's accountabilities and responsibilities are? Do we have new employee orientation? Do we have training for managers? Do we have training for new supervisors coming online? How about record files? Do we have good personnel documentation? Is there a way to store it electronically? How about employee rights? How far can an employer go in a number of areas? How far can an employee go without being subjected to termination? What does the law require? A lot of these things we get right into and deal with on a regular basis. For us, they're fun. I am a labor attorney and have been practicing, I hate to admit this, for almost 39 years. And I started when I was a baby, as you can tell. We've been working on a lot of crisis type situations for employees when they have a problem. And crisis situations are really, I define that as anything you're not ready for, where an employee comes in and says, I have a problem, can we talk? And you sit down and say, okay, this will be one for the record books. What are they going to ask me? Do you already have employees? Does synergy really work for you? Are you about to hire some employees? Do you know what the rules are that you have to have if you have employees? Are you about to release somebody? That's one of the largest red flags that I can think of. If you're going to hire someone, are they going to be full-time or are they going to be part-time? One of the big areas of the law that is subject to a lot of review these days is, are the employees exempt or are they non-exempt? Meaning, are they subject to receiving overtime or are they more on the management side? There's lots of Department of Labor investigations into claims that some employers and really people that just are not comfortable or knowledgeable about the law fail to pay overtime and classify everyone as exempt. That is really rampant these days, and the Department of Labor is doing lots of on-the-spot investigations. Releasing employees is probably, as I mentioned, the highest risk situation you have, and I'll get into some lawsuit dollar amounts that I think will kind of take your breath away. Most of them, and that's one of my closing slides, it talks in terms of settlements, not the actual lawsuits and not actual attorney's fees. Some of you may want to utilize what I call independent contractors. You want to be very careful that they are truly independent, that they're not employees, because there too, like with the exempt, non-exempt issue, lots of Department of Labor investigators and IRS gets involved in determining whether or not they are independent. And as you can tell, if somebody is an employee or should be an employee that is classified as a contractor, there is the chance that there's a bunch of payroll taxes that aren't being taken out, withheld, that could create a serious issue for the employer down the road. So understanding who's 1099 and who's W-2 gets to be really important. And again, we do advise companies that are thinking about hiring employees that want some groundwork laid before they arrive. The first employee arrives and you sit there and scratch your head, now what do I do? One of the things that we like to describe is an approach. And we always like the fact that somebody sits down and says, what should I do? We can help in this regard. Planning is really important, that you have an HR plan. How are you going to handle the employees? Are they going to be supervisors? Again, are they going to be exempt, non-exempt? Are they going to be 1099 employees? Do you have job descriptions? Do they clearly understand what their roles are? Do you as an employer understand the legal requirements? Do you understand the laws in Minnesota? Minnesota, I think you're probably aware, is a fairly liberal state when it comes to protection legislation dealing with employees. The rights to review employee files, discrimination charges are very easy to bring under the state statute. The state statute is more protective than even the federal statute when you run down the list of race discrimination, disability, religious accommodation, national origin discrimination, sex discrimination, and my current favorite, because we're defending a client in my world right now involving an age discrimination problem. You should develop a formal plan. This is something I can help with, that Synergy does routinely. I do a lot of the fulfillment work, as does my partner, Michelle. My role is that of the Chief Technical Officer for Synergy. We have a number of other people in the company that help out. We do run hotlines, and we do have a variety of resources available to bring to bear. Here's some common questions, and I have a couple of quick stories to run through on this. Many of you are aware that social networking is a hot topic in HR circles these days. A lot of employers are using Twitter, Facebook, etc. to investigate employees in terms of their personal lives. There's some case law beginning to come through indicating that this can potentially be an invasion of privacy. Some employers are demanding that employees cough up their passwords to Facebook and whatnot so that they can examine what employees are doing, sometimes while at work, sometimes while not at work. There are major issues that are coming up. Even somebody like the National Labor Relations Board has issues with employers' use of social networking. Every now and then, and there's currently a case that is going to cost the employer about $300,000, where the employer said, you're fired because you and another employee were talking on social media about, and you were complaining about the benefit structure at XYZ company. The National Labor Relations Board, which typically supervises union organized companies, can also step in non-union organized companies, and it's something called a Section 7 right, meaning it's protected activity that an employee has the right, when it comes to benefits, compensation, and other terms of employment, wants to talk about their benefits or their comp with another employee. That is legal in Minnesota. And when an employer steps in to say you can't do that and fires somebody on the basis for that, there's a problem. And in this particular case, it's going to cost them about $250,000. One of the things I like to always mention, if you don't know it, if you have 20 employees or more, a Minnesota Parental Leave Act applies, and this covers parental leave type situations. It's unique to Minnesota. It is the law of the land in this state. Again, it's an employer size of 20 or more employees. So if you, I won't go into detail, but the PLA is something to be dealt with if you're putting a handbook together and you have 20 employees or more. Family Medical Leave Act gets even bigger in terms of an employee type size as a company, and that applies if you've got 50 or more employees. And that is really technically important to comply with. There's lots of issues and problems, but again, I won't go into detail. That's for 50 and up. One of the things that does come up for any size employer, and that's the use of arrest and conviction records. Be careful with those. Arrest records are it's almost to the point of saying they're hands off. Conviction records, if it relates to the job function in any way that you can imagine, a conviction record can be a reason to exclude an employee from hire. An arrest record, however, has to be considered to be directly related to the function the employee is going to serve for the employer. And if you have an arrest and you do a background check, an arrest pops up on a background check, and you think it relates directly, let's assume maybe it was an arrest for failure to pay child support, and you've got somebody in a customer service role. That probably is not going to be a bar to hiring that individual, or would not be a good reason not to hire. Somebody who is a bank teller who's been indicted and arrested for fraud, well, that probably would apply. Workplace bullying is a hot topic in HR circles these days. A lot of employers say that we have to be careful. Anybody that argues that they're being bullied by a supervisor can sue us. I probably take a much more conservative approach and say if it's within the parameters of a supervisor's job and it's job related, an employer can talk to their employee any way they want to that's reasonable and appropriate under the circumstances. Somebody could argue that my supervisor yelled at me 3 times in a row for failing to finish a job properly, and that's bullying, and therefore I'm going to sue you. There is no basis for a lawsuit in Minnesota for what a lot of people mistakenly refer to as bullying, at least not yet. There has to be an allegation that there's a ground of discrimination or something else going on in the workplace. Here's a few more things to consider. One of my partners, Brett, put this slide together, and he really nailed it. There's a variety of things to keep in mind. These are topics that we deal with routinely. Harassment claims is something to worry about, especially in the event it's a hostile type environment, especially if you have a woman. But what many people are not aware of is under Minnesota law, it can also apply under certain circumstances to a male as well. Minnesota Prevailing Wage Act is appropriate to pay attention to. It's more restrictive than the standard of the federal. And what I would tell you, as my partner Michelle and I spend a lot of time advising employers, that if the state law says something and the federal law says something, if it's more beneficial to the employee, then that law applies. Minnesota has a mini COBRA statute, which relates to continuation of benefits. Do you have non-compete agreements? Do you want one generated? We can help. OSHA compliance is pretty important. My OSHA, as it applies on a state basis, is alive and well in Minnesota. Minnesota is an at-will employment state. We like to make sure that all our clients take advantage of that to the maximum. we deal with a lot of unemployment appeals where somebody potentially was terminated for misconduct. They are not entitled under Minnesota law to unemployment compensation, and we defend a lot of employers regarding that. Child Labor Act comes up once in a blue moon. Discrimination claims, somebody feels that they were wrongly treated or terminated for a reason based on a protected class status like race. That could be a basis for a claim. Keep in mind, in Minnesota, there's a very proactive Equal Opportunity Employment Commission and the Department of Human Rights. Both of them are watchdog agencies that can create problems for employers because they do not require an attorney to bring a claim. They can simply go and make a complaint regarding some form of discrimination like age, and that government agency will investigate it and ultimately could decide to take the employer to court. In the event they don't, they typically issue what's called a right to sue letter and let employees then go through the process of bringing a lawsuit. We do get involved in a lot of settlement, mediation, negotiations. I am a licensed mediator in the state of Minnesota. We do like to help clients try and do a win-win solution for a problem. And I'm not even going to attempt to talk about qui tam. One of my partners put that in, and he bet me, let's just say the government has to agree to let you sue, and it gets pretty complicated. Do you need an employee handbook? We always toss that out. Even if you have a couple of employees, does it make sense? You know, you really need a roadmap for employees. You really need to set forth what your expectations are as an employer. It's information for the employee. You confirm that they're at will. You confirm that there's no contract for employment. You basically get them to agree to follow the rules. You can get privacy sign-offs in terms of dealing with the company's trade secrets, confidential information. It gives you the right to enforce your rights as an employer, and at the same time gives the employee some really good information about what they probably want to hear about. What are the payroll practices? What are the benefits? What are the rules that they need to comply with? A lot of people claim, well, if I have an employee handbook, it's hard to keep it updated. Once every couple of years for a couple of hours, we can buzz a handbook and get it up to date pretty quickly. It really is not a big issue. A number of employers feel that, well, maybe I just won't have a handbook. That way I won't have to, you know, update it. That way I won't have to deal with any of the issues that come up. I recently advised a client that has 400 employees here in the city of Minneapolis that does not have an employee handbook. And they are being taken to the cleaners lately with a couple of lawsuits relating to how they treat. They have a number of Hispanic employees, and those Hispanic employees are bringing lots of national origin and race claims. Why is all of this important? Number one, West Group settled a wrongful termination lawsuit for $3,700,000. An average nationally for wrongful termination type claims, this, if I remember, Brett, was based on age. Yes. These are growing, and keep in mind, it may surprise you, under Minnesota law and federal law, you are old if you are 40 years of age or older. So bad news today is, or maybe the good news is, that you now know whether you're in the protected age classification or not. What I would tell you before, a little bit about Minnesota law, why it's unique, is that Minnesota has added to the federal standard of the age 40 and basically said if you're 18 years of age and older and you're discriminated against because of your age for any reason, that is prohibited in this state. Here's one for $160,000. It was an employee discrimination suit settled by Target. The average for discrimination claims, and these, by the way, as Brett has advised me, don't have anything to do with attorney's fees. These basically are to make the plaintiff go away, and there is some acknowledgement that something happened that shouldn't have happened in the workplace. Again, part of our role at Synergy is to make sure these things don't happen. We take a very proactive approach. Sexual harassment claims, Minnesota Publishing Company settled one for $150,000. The average for sexual harassment claims, which includes hostile environment claims, averages about $217,000 nationally. So we're not trying to scare anybody with this, with these statistics, but it does cost money if there's an issue or an error made in the way you either treat an employee or the way a termination is handled. And a lot of times, if you're going to deal with somebody's a problem in the workplace where there's maybe going to be a suspension, considering a termination, considering somebody filing an internal claim or a grievance, it's usually a good idea to pick up the phone and give us a call before you have a problem, before you take the action. We can really help solve issues. How do you protect yourself? You maintain some really good documentation. You have an employee handbook. You keep it up to date. You stay current with regulations as they come up. You have your HR plan, as I talked about earlier, and you follow it. You do regular reviews. These can be policies, procedures. They also involve employee performance reviews. We call that a performance evaluation system. And of course, last but not least, consult an expert that deals with these types of problems, because as we talked about earlier, let's see if I can shoot back up, just to make the point, small businesses typically are unprepared for a lot of these issues and problems that we've talked about. And part of our job is to keep you prepared for those issues, lets you keep your eye on the ball, lets you worry about your bottom line and doing what you do best, which probably does not involve dealing with HR issues. Thank you, everybody. Very good.